would have wanted them to be his agents if he had gotten around to doing a financial power of attorney. There is no default like that. And so Rod's simply going to be left without any financial power of attorney if he didn't opt to do one while he had the mental capacity to do that. And I put in there that a financial power of attorney is essential to good planning because the alternative is legal guardianship. That just means that the law is not going to allow a beloved family member to come along and claim, I should be appointed as agent, even though, you know, my spouse, my parent didn't name me as such. They're going to have that loved one is going to have to go into court and request a legal guardianship. And that's going to be a very time-consuming and expensive process. So that's what I mean by there's no default. The law won't impose any assumptions about who you would have named if you don't get around to doing one of these documents. A hallmark of a financial power of attorney or a durable financial power of attorney is that it's effective immediately when you sign it, and it remains in effect even if you become disabled. And if you think about it, that makes sense because you can't wait to do this document until you're already incapacitated. I, as an attorney, cannot put in front of you a document and say, I know you don't understand this, but you really need an agent, so please sign this document, you know. So it's in effect when you sign it, and you sign it when you have mental capacity, and then it remains seamlessly in place through any period of incapacity. The third bullet point here says you do not have to have the ability to physically sign the document. You do have to have the mental capacity to understand what you're signing. And if there's any question, and I'm asked to prepare a financial power of attorney for someone, that's going to be on me to ascertain if this person knows what he or she is signing. I don't ask picky things like, you know, how many electoral college votes are there? But I do ask, you know, are you oriented to whom you love and trust in your life? You know, whom would you name and trust to handle your finances? That kind of thing. And do you have a general sense of whether you have $10 or $1 million? So, yeah. So you have to have adequate capacity, but you don't have to physically be able to, you know, hold a pen and legibly sign your name. There are ways around that. Whom should you appoint as your agents? That's going to be a very personal kind of decision. I often get the question from people, is it a problem if I appoint essentially the same cast of characters to all my important positions, like my agent for healthcare decision-making, my agent for financial decision-making, my executor under my will? And my response is that I do not see a problem with that. That's very common. If you trust someone to act appropriately as your agent during your lifetime, that makes sense to me that you would also trust them to faithfully administer your will and your estate. Moreover, if you do appoint someone to act, for example, as your agent for finances during your lifetime, then they're going to have a leg up in understanding your estate and your estate assets when they come to act as your executor. So I don't have a problem with that. The durable financial power of attorney, just a couple other comments about this document. In 2015, the Pennsylvania legislature changed significantly our law about what a financial power of attorney must include. And the legislature added a whole section that we refer to as the expressly granted powers. And all that means is that if you omit explicit reference to certain powers in your document, the assumption is that you intentionally withheld those actions and those authorities from your agent. So an example of an expressly granted power would be the ability for your agent to make gifts, or to disclaim something that would otherwise be coming to you, or the ability to amend a trust, or the ability to change a beneficiary designation on your IRA. Those are 4 examples of expressly granted powers. The law says if you have a power of attorney and it is silent on those actions, in other words, the document nowhere says that you're okay with your agent taking those actions, the law assumes you intentionally don't want your agent to do those things, and that's rarely the case. And so it's really important to review your old financial power of attorney. If you have something from the year 2000 or 1998, pull it out, look at it. Chances are it's going to be a good idea to update it, just so your agent under that document doesn't get pushback when he or she tries to act on your behalf under that document and is told, you know, I'm sorry, we don't see any explicit authority in this document for you to take the step that you're trying to take. And I will say in my practice that the lack of a good financial power of attorney or the presence of a very old, inadequate power of attorney is probably the single biggest problem that confronts my clients week after week. I deal with it. I mean, rarely would a week go by that I'm not working with someone who is stuck with a very old or inadequate financial power of attorney, trying to do something for someone who no longer has the capacity to update their financial power of attorney. And had they known, they would have. Yeah, and so, yeah, the problem is the last bullet point elucidates here. Your agent may run into a financial institution who simply refuses to accept the agent's authority because the agent has, or the financial institution has its legal department review the document and they say, this is too old, this doesn't have expressly granted powers, we're just not going to cooperate, you know, with this agent. Okay. And then very briefly, the second type of power of attorney, those two lifetime documents, one for finances, one for healthcare. I think most of you are familiar with the concept of what a living will does, expresses your desires about receiving or not receiving certain medical interventions when you're incompetent and either end stage medical condition or in a state of permanent unconsciousness. And then it permits you, the healthcare power of attorney, often combined with the living will, permits you to say, who is it who I would want to make medical decisions on my behalf? I just want to comment that if you are appointing a team of people to act as your agent for finances and your agent for healthcare, make sure they get along. And I'll give you two examples of how that can, why that's important. Let's say you are a parent who appoints two children as your co-agents for financial decision making. One of those two children then invites you to come live with them, and that child becomes your caregiver, and that child wants to do a written caregiver agreement, which we'll talk about in a bit. Now you have two children, both with the authority to determine what a payment is suitable from you to that caregiver child. If the caregiver child says, I am working so hard, I gave up my day job, I would like to receive $25 an hour for $12 a day for the work I'm doing for mom. And the other child, who's the co-agent for financial decisions, says, I think $7 an hour is more appropriate. You know, we're all doing things for mom out of love. You have a real problem on your hands because now you have two agents who can't agree on the key terms of a written caregiver agreement. Another scenario is, let's say you've appointed your daughter as your agent for healthcare decision making, and that document says that she has the right to enter into agreements for your care. She has the right to engage or dismiss medical, social service support personnel, etc. That's her prerogative as your agent for healthcare decision making. But you go to live with your son in his home, and hospice and a private nursing care agency are involved. Brother and sister have friction because sister has the document giving her authority, sole authority, to determine what outside agencies can come in and do what services for you, but it's her brother's home. Now you have a problem. So the moral of this story is, if you don't consolidate power of attorney authority for healthcare and finances in the same people, at least make sure those people have a good working relationship. Yeah, so you don't get caught in the middle. Okay. That's as far as I'm going to go on estate planning. Estate planning documents, make sure you have good, comprehensive, up-to-date financial power of attorney and living will healthcare power of attorney. My second point I want to cover here is just the different options that would exist for paying for in-home care. So obviously out of pocket, you know, if you have substantial savings and you want to hire your own, in-home nursing service, you can certainly do that. I am going to spend a little more time on the other bullet points here, the long-term care insurance option, the options program option. All I'm going to say about Medicare is that there is a very limited home health care benefit. And then I'm going to spend a little bit of time on a special type of Medicaid program that provides for in-home care or provides payment for in-home care. Long-term care insurance is another one of those topics that could be a whole presentation in and of itself. Just to let you know that if you have purchased a Pennsylvania policy after the date that you see here, July 17, 2007, that policy is going to include coverage for home health care. It just is. And I rarely these days review policies that don't have a home health provision. Some of the very oldest policies I see might say this policy is only going to provide coverage for a nursing facility, but that's increasingly rare. I always tell clients, if you aren't sure whether you have met the triggers for your policy to begin paying you, make the claim. If you're unsure, make the claim and, let it be seen whether or not you've met that criteria. Many people have trouble finding their whole policy. They give me like one-page schedule of benefits, and they're really kind of confused about where their actual contract, the original full contract that has definitions and terminology, they're not sure where that is. If that's you, then I would urge you to write to the company that you have long-term care insurance through, if you do have a policy, and ask them for a copy of your entire contract. Be familiar with the definitions. They're going to define things like home health care. They're not going to leave you guessing what they mean. And also be familiar with any riders that you purchased. I find it's really common that people purchase their policies so long ago and they're just faithfully paying the premiums year after year that they've actually forgotten what full coverage they have. And they've forgotten, in many cases, when they opted for certain very excellent riders, like an annual inflation cost of living rider, where their benefits going up every single year for multiple levels of care. Or they've forgotten that they purchased this extra home health care benefit when that's exactly what they need. So they've already paid for it. The issue is, do they remember they paid for it? And do they remember that their policy has that provision? And do they make the claim? The last bullet point here is that Pennsylvania long-term care insurance laws do guarantee a right to appeal an insurer's determination that a benefit trigger has not been met. And I have had really excellent success with Pennsylvania Department of Insurance. They are really on the ball. When they feel that a consumer has purchased a policy with certain coverage and that consumer is getting pushback on the actual payment of benefits, they are prompt and they are active. So it is not a bureaucracy, that is unsatisfying to deal with. So not everybody has long-term care insurance. In fact, maybe most of the people on this call do not. The options program, I just want to make you aware of this. It is a program that provides in-home services to people who are living independently, but they're having trouble with some of their activities of daily living. They're getting dressed, they're toileting, bathing, etc. Depending on your income, you might be required to pay a portion of the cost, and it is intended for socially and economically needy older adults. The criteria, just really quickly, and you can find these on the Office of Aging website too, have to be at least 60, you have to reside in Lancaster County in a non-institutional setting, so like your home. You have to have some disability that requires assistance for you to remain living independently, and you can't have informal support from your family or others that would, make it possible for you to live independently. And there is verification of income and assets to determine whether you need to share costs. I'm going to spend a little bit of time here, a little bit more time on this payment option, medical assistance. And I do understand that February a year ago, in addition to estate planning, you had a specific program on Medicaid or medical assistance. And I'm going to warn you, I use those terms interchangeably. I mean the same thing. When I say Medicaid, I mean medical assistance. And what I'm talking about here is a very particular type of program for older Pennsylvania adults. This is not the Medicaid or medical assistance that you might be aware of for a younger, low-income person with disabilities. This is a very particular form of Medicaid. The program that you were given a year ago or a year and a half ago really dived into the details about financial eligibility. I don't have time to do that today, and I don't know that you would want me to do that today. It's an incredibly complicated program, but it is a really helpful program, and I am always working with at least 5 or 6 people who are in the process of qualifying for Medicaid, whether they be people searching for facility, traditional skilled nursing care facility Medicaid, or Medicaid delivered in their home setting. That's a special kind of Medicaid, and that's what we're going to focus on today. This slide, all I want you to take from this is that the agency that administers Medicaid, whether it be nursing home Medicaid or in-home Medicaid, is the same agency in the state of Pennsylvania. It's called the Department of Human Services, and its local county representative is called the County Assistance Office, or the CAO. And I want to give a little bit of a shout out to Lancaster County CAO, because we work with them very, very regularly. And I will say that they are actually really quite professional and excellent to work at. And they are not making it their business to keep people from qualifying who are eligible to qualify. Eligibility requirements, just going to speed through these. Really, I want to focus on the last 2 here. There's always 2 prongs for medical assistance of a long-term care nature. Those 2 major prongs are that you have to need the service, you have to be medically or functionally needing medical assistance, and then you have to be financially eligible. I am going to just give you 3 very broad features of financial eligibility. I'm not going to get down and dirty into some of the details. Whoops, a little too far there. What I want to say about financial eligibility for Medicaid, three big points to remember. Income is treated very differently from assets or resources in the world of Medicaid. I've realized in working with clients over the years that they will use income and resources kind of interchangeably. And it's important at the outset to understand for almost any Medicaid program, there's going to be very discrete income requirements versus assets and resource requirements. By income, I mean Social Security retirement, pension, rental income from an investment property. That's income. By resources or assets, I mean what you would put down on a net worth statement, your bank accounts, your house, your car, your investments, your IRA. Those 2 categories of resources, or those 2 categories, income versus resources, are treated very differently within the world of Medicaid. And so we have to make sure we're talking about the same things when we look at eligibility. The third big picture piece about financial eligibility for Medicaid is something that is kind of infamous. Many people know about this. It's called the Medicaid look back. If I could see a show of hands, I would just ask, I am always amazed how many people have heard stories about the Medicaid 5-year look back. And we're going to talk a little bit more about what the look back is, just because it's so critical to understanding things like written caregiver agreements and why do we put caregiver agreements in writing. And it's very important to understanding the last bullet point we're going to talk about today, the caregiver child transfer exception. So the look back is always looming in our rearview mirror. Whenever we talk about Medicaid, it's important to understand that the Medicaid agency says, in exchange for us coming along and giving you this valuable long-term care benefit, your skin in the game is that you have to reveal and disclose to us, the state Medicaid agency, really everything you've done of a financial nature over these past 5 years. We want to make sure that your strategy wasn't just giving your house away, giving your bank accounts away, and then throwing yourselves upon the mercy of the Medicaid agency, saying, I have no money, I need you to pay for my in-home care. That's why we have a look back. I do want to make a comment too that I think in the world of Medicaid, single people and married people are treated very differently. And what I mean by that is that the law has very specific anti-spousal impoverishment rules against impoverishing a spouse. Those rules are very generous to a married person whose spouse needs skilled care, whether received at home or in a facility. There is no comparable asset protection set of rules for non-spouse family members. So as we talk a little bit about gifting and transfers and the 5-year look back, just be aware that there are very lenient rules, essentially no rules for transfers to a spouse. It's just not going to be a problem, no matter what you're transferring to that spouse. But there is going to be a problem if you're making transfers to a child or to a good friend. So I think it's just important to acknowledge that the law is somewhat more generous in terms of transfers to a married couple. The waiver program that I want to talk about is Medicaid that you receive services in your home. What would be an example of the kinds of services that one could receive at home with the tab picked up by Medicaid, assuming you meet both the medical eligibility prong and the financial eligibility prong? Long list of services. It could be home delivered meals, home health service, personal assistance services, respite, service coordination, nursing services, therapeutic services, assistive technology, speech therapy, language therapy. There's no cap on the services. So the Medicaid waiver program, and I have it here referred to on this slide as the aging waiver program, means home and community-based services to seniors who would require nursing facility care, but they elect to live and receive care in their own homes. And let me just breeze through this financial eligibility section. All I want you to take away from this is that I just made a big deal a few minutes ago of how income eligibility requirements in the world of Medicaid are very different from resource eligibility requirements. All you need to remember from today when you think about, oh, the Medicaid that can be delivered in a home setting, just be aware that there are different rules about maximum income for this type of in-home Medicaid than there are for nursing home Medicaid. But the same rules apply to assets, resources, and the same rules apply about gifts. What you can give away and still qualify for these programs. So just to be specific on that, to qualify income-wise for Medicaid's nursing home program, you just have to have monthly gross income that's less than whatever the nursing home would charge for skilled care in 1 month. And the little asterisk just points out that really this is not at all a hard standard to meet, because average monthly skilled nursing care in Lancaster, actually $11,000 a month is low, to be honest. I see them up to, the cost can be up to $15,000 a month. So I don't have many clients whose gross monthly income exceeds $11,000, $12,000. Occasionally someone with a very excellent long-term care insurance policy that's paying them benefits directly, and then they also have Social Security or pension, they might bump up against, their income might bump up against the amount that they're owing the nursing home. And so there might not be an ability for them to show need for Medicaid in a nursing home, but that's rare. The income requirement for the in-home Medicaid, the waiver program, there's a bright line rule, and your gross monthly income cannot exceed $2,349 a month. That's the 2020 number. For a long time, that number really frustrated us, because I'd have a client whose gross monthly income was $2,400. And sorry, you're just out of luck, even though you're an excellent candidate to receive care at home. That just seemed ridiculous. Fortunately, we've had a bit of a change here in the last year. The Department of Human Services now offers something called a qualified income trust, or today I was talking with them and they're calling it a pooled trust. If you're over 65 and you're applying for this type of in-home Medicaid, where you want to stay at home, but you want Medicaid to pay for a variety of service providers to come into your home, you can now set aside whatever additional income you have each month that exceeds that $2,349 limit. But there's not an endless cap. You can only set aside up to another $499, essentially $500. And you're going to have to spend that excessive income that you've set aside in a trust on unreimbursed medical expenses. So it's a start, and I would say stay tuned to see if the law helps us out even more in this area, because we all give lip service to thinking more people should be able to remain at home to age, and it's certainly far less expensive for Medicaid to pay for in-home care than nursing facility care. So hopefully the law keeps evolving to permit more and more people to not bump into this income cap. So yeah. Let me just make sure I didn't want to say anything else about that. Yeah, so for high income people, Medicaid received in-home through the waiver program is still not going to be much of an option. If you have, excessive monthly income, in excess of, say, $3,000 or $2,800 at this point, it's still not going to be an option. I want to just cover a bit, very briefly, the Medicaid transfer rules, because they do form the background for the last two things we'll talk about, that written caregiver agreements, why we do them in writing, and the caregiver child transfer exception. The 5-year look-back period that I keep alluding to means that for 5 years before you seek medical assistance, financial help to pay for your care, received at home or received in a facility, you cannot have made gifts or transfers for less than fair market value. You can't have given your assets away. If you have, you do have a chance to cure those gifts. If the person you gave gifts to has the ability, they can return those gifts. But if they can't, then you just know that you're probably facing what we call a penalty period. And I'm just going to show you a really simple example here. Let's say you gave $50,000 to your child 3 years ago, and this year you are an excellent candidate for the Medicaid waiver program. Your income is the right amount, your resources are positioned right. You want to apply for Medicaid to stay at home and receive care in your home, but we have this problem of the $50,000 you gave away 3 years ago. How do we figure out what that's going to result in? We divide it by this penalty divisor that you see here, and we're not going to talk too much about this. Suffice it to say, there's a way to calculate how many days of penalty come from a dollar amount of a gift that was given within the last 5 years. The point I want to make here is that when you're in a nursing home, you apply for Medicaid and you reveal that you gave away a $50,000 gift within the 5-year look back, we can figure out exactly the impact of that gift, because all we have to do is divide our $50,000 gift by our penalty divisor, and we say, oh, we have 142 days of penalty. So that just means, and actually I'm going to go back, that just means that for 142 days after you otherwise would have qualified for Medicaid, Medicaid's not going to pay the nursing home. You or somebody else is going to have to figure out how to do that because of that gift. It's a little different with the at-home waiver program for two reasons. I'm going to try to explain without getting too bogged down here. So this slide describes what I just said in the last minute here, that when you make a transfer and you're seeking Medicaid to go to a nursing home, then your ineligible or penalty period is going to start on the date that you're otherwise eligible for Medicaid, but for that gift you made. So we can figure that out pretty precisely. If you're a waiver applicant, we're going to have to look at the date your application is actually approved, and we're not going to be able to say that the period of time while your application was submitted and while you were paying privately for in-home services, waiting for Medicaid to come along and say, okay, now we're going to pick up your in-home care costs, that whole period is not going to be coverable. In a nursing home, you're presumed eligible when you submit an application for Medicaid, and you can submit an application up to 3 months after you claim you were financially eligible for nursing home Medicaid. The rules about eligibility for the in-home waiver program are very different, and so all you should remember is that if you've given a significant gift and you're facing a penalty and you want at-home waiver Medicaid, it's going to be a little trickier to figure out how long the penalty period is when you would otherwise be eligible for Medicaid to pay your in-home costs, but for that gift you gave away. And this slide explains what I just said about there's presumptive eligibility for nursing home services and a 90-day retroactive eligibility coverage period, but there's no such presumptive eligibility for waiver services. You have to just simply pay out of pocket while you've submitted your application, while you're waiting. Even if you haven't given a gift, you're sitting there waiting for approval and you're paying privately. So you wouldn't want to wait too late until you have no money to pay any in-home caregivers on your own. I'm going to move to my last two more specific points about written caregiver agreements and the caregiver transfer exception. We're going to talk about what a caregiver agreement is, what it should include, and when it should be signed, and then formalities that should be observed. Let me just quickly check my time here. Okay, we're okay for now. A written caregiver agreement, it is what it sounds like it is. It's a written agreement between someone who's providing services and care and someone who's receiving care. It should be detailed. It should specify what services are being provided. And I've got lots of examples there I'm not going to read through. The second bullet point here is probably the most important point I'll make about caregiver agreements. It specifies a reasonable and contemporaneous payment compensation arrangement. No retroactive written agreements. We don't like those. The law doesn't want you to say, oh, over the past 5 years, I've paid my daughter $1,200 a month. That's not acceptable. You can't document in writing what you did over the past few years. The agreement should be prospective, going forward. Starting in October of 2020, I'm paying my daughter $1,200 a month because she's helping me every day with my prescription medications, my shower, toileting, laundry, taking me to doctor, etc. And it should avoid, the caregiver agreement needs to avoid duplicate payment. So if there's two granddaughters, they're each providing care, they need their own separate caregiver agreements. And certainly if you would go to a nursing facility, someone who's been providing you care in your home cannot continue to receive any kind of payment. The importance of the Medicaid gifting rules is simply that if you are paying someone to give you care and you have not documented that in writing, in a prospective agreement moving forward, the law will presume that you are giving gifts to that caregiver every month or in a lump sum. And Medicaid law will put the onus on you to prove that those were not gifts. And how do you prove that if you never bothered putting anything in writing? That's the dilemma that has really confronted a lot of people who've come to us to say, oh yeah, you know, for the past 3 years, I've been paid this amount. It was a verbal agreement. We both agreed to it, Mom and I. But now we're going for Medicaid and we have bank statements showing these regular large payments, and there's going to be a presumption that the entire thing was a gift because we have no documentation that this was an approved agreement. I want to just tell you about a poor daughter in a case in Lycoming County from last year. This case was really, really helpful for elder law attorneys, helping us see, even though it's not a precedential case for the whole state of Pennsylvania, here was a judge analyzing what went wrong with a written caregiver agreement that a daughter had put in place for her mother. The caregiver daughter for 18 months prior to her mother's death, provided extensive care, really round-the-clock care, and was wanting to be paid $1,200 a month. She didn't take any payment during her mother's lifetime. She waited until after her mother's death, and then she presented essentially an invoice for services to her mother's executor. And the executor said, not going to pay it. No, I'm not going to pay this, whatever it was, $21,600, even though there was a written agreement. It went to court. Why did the court deny compensation to this daughter? I actually feel really badly for this daughter. There was no dispute. If you read the opinion, the judge never doubted for a second that the daughter actually provided the care that she said she was providing. And the judge never said that $1,200 a month is unreasonable. In fact, I think it's highly reasonable. There was no dispute about that. The problem was the daughter was her mother's agent under a financial power of attorney. Daughter drafted the agreement and she signed it. She signed it as the caregiver, and then she signed it as her mother's agent too. So she signed it on both sides. And the judge said, I don't feel good about that. I feel like your mother was totally dependent on you. You had total control of her finances. You were her agent. Why didn't she sign it? Like, how do I know that she actually understood and agreed to the terms of this agreement? I've heard no testimony here from someone else other than you that she couldn't sign it. She didn't have capacity, so you were forced to sign it. There's no medical testimony from her doctor saying, yeah, she really had no capacity, but I'm confirming daughter did all of this. So the daughter simply couldn't satisfy the judge that there was no self-dealing or not self-dealing, that there was no sort of self-interest here. The judge said, I just feel like, you can't meet your burden of proof that your mother knew and understood and agreed to these payment terms. Also, there was no attorney involved. The judge didn't like that. There were no witnesses. There wasn't a notary. So, the most important point is don't do it yourself. Get somebody else involved. Don't just be in the position. I felt this did provide the care and did not ask for an unreasonable amount of compensation, but she absolutely shouldn't have drafted it and signed it in both her capacities without getting some kind of medical testimony. She shouldn't have waited till her mother's death. She should have been taking payment every month. So yeah, this was a bad situation. So that's the moral of the story. So yeah, attorney drafted versus do it yourself. And of course you would assume that I as an attorney would tell you that you should have an attorney involved. And that is what I'm saying, but that's based on the judge's statements, not just my own. Have the parent, or you as the parent or the elder, should sign the agreement in your own capacity if at all possible. You should have witnesses, disinterested witnesses. You should do, the courts seem to like ongoing monthly payments better than one lump payment. And then again, my little constant refrain is that payments should begin after the contract is made. They shouldn't be retroactive payments. And I think it's also best practice to seek buy-in from other family members. The example I gave up front about a caregiver daughter thinking that she's entitled to $25 an hour, and her sister, her co-agent under mother's financial power of attorney, believes that she's only due $7 an hour. That is not a made up, I mean, these things happen all the time. Caregiver agreements where a parent is now reimbursing a caregiver child can really bring out the worst or the best in families. So yeah, and very common additions to a written caregiver agreement that we would do if the facts support it is document that, if you are a member of a household, you can be reimbursing the caregiver. In addition to the care received, you can be reimbursing that caregiver homeowner for your pro rata share of groceries, of utilities, etc. That's perfectly acceptable, and it's a expense reimbursement, not a taxable caregiver agreement. So when you're paid for care as a caregiver, that's taxable reportable income, but not so with a simple household expense reimbursement. So document that in writing. There are a number of clients who a parent has moved in with a child and they have built on an addition. That might not be quite as common in downtown Lancaster type housing as it is in the suburbs. But if you're going to invest a big chunk in modifying your caregiver's home, you need to document that in writing, or the presumption can easily be that you just gave a $100,000 windfall for a very nice home renovation to your caregiver child. I'm going to end with this caregiver child exception to the Medicaid transfer rules. What is it? What are the requirements that must be met? Why is it important, and when can the transfer take place? What it is an exception to these Medicaid transfer rules that penalize uncompensated gifts and transfers. This exception says, hey, normally when you give your home to your child, or you put your child's name on the deed to your home, that's a gift, and that's going to cause problems for Medicaid if you did it within 5 years of submitting an application for either that home Medicaid or the nursing home Medicaid. But in this instance, Medicaid is going to look at that transfer of the home to a caregiver child and say, that's okay, we don't have a problem with this. And why don't we have a problem? Well, because certain requirements have been met. The asset that was transferred was the resident's property, and title was transferred under these conditions. I have all of these bullet points in color because I want to really drive home that every single one of these is critical. It's not a, if you meet one of these, you're fine. It's a, you must hit every single one of these on the head or you don't have a good case for a caregiver child exception. So the first point talks about a son or daughter who you're transferring your home to, a son or daughter who resided in your home. So we have tried with grandchildren, not sure we've had the greatest of luck. We have, you know, it has to, as a son or daughter, so it means a son or daughter. For at least 2 years. So the child has to have resided in your home at least 2 full years. So it can't be, oh, they moved in with me 10 months ago. Do I meet the exception? No. And they have to have lived with you immediately before you became an institutionalized individual. And I'll explain what that means. That doesn't mean quite exactly what it sounds like it means. And this son or daughter who has been living with you for at least 2 years immediately before you became an institutionalized individual, that son or daughter has to have been care of a very explicit type, not just I'm your roommate, I help out with some laundry and meals. This is care that is intensive. This is care that permitted you to stay in your home when you otherwise would have actually met the criteria to need a skilled care facility. So why is this transfer exception important? It's important because if you qualify for Medicaid, either this waiver program I'm talking about or a nursing home Medicaid, the home can remain titled in your name up front and you'll be able to become eligible. But at your death, that home will be subject to what we call estate recovery rules. The 5-year look back is infamous on the front end of Medicaid. In the same way, the phrase estate recovery is often kind of infamous on the back end of Medicaid. And what I mean by the back end is what happens after the death of someone who received Medicaid benefits. State recovery will say, we were very happy to provide in-home waiver benefits and pay for them, you know, during your lifetime. But now that you're gone, we're going to look and see, is there anything left in your estate that might help us partially recover all of those Medicaid benefits we paid out? If there's a house left in your name, that's going to be subject to estate recovery. This caregiver child exception is a way to ensure that the home can go instead to that caregiver child and not be subject to the estate recovery rules. When would we ever do this transfer of the home to a caregiver child? If we've met all those 5 colorful bullet points I just had up, we still would wait to do the transfer until the parent is either in an institution or is determined by our Office of Aging to need that level of care, but they could be receiving care at home under that waiver program. And we need a doctor who says all of those 5 colorful bullet points have been met. Parent needed this kind of care for 2 years before they were actually admitted. To the best of my knowledge, doctor says the child has resided in the home for at least 2 years, and but for that care, this parent would have needed nursing home care at least 2 years earlier. We'd still then wait for Department of Human Services Counsel to review and approve that transfer exception before we go ahead and do a new deed. And then to keep the peace in the family, what we often do is we have an acknowledgement signed by other children to say, I understand what's going on here. Mom and dad's home has a value of $275,000, but my sister lived with them for 3 years, you know, prior to mom going into the nursing home, and my sister provided intensive care. And now I understand that you've sought and received permission from the Medicaid agency to transfer mom's home to my sister, so it's not subject to Medicaid estate recovery. And I'm good with that. So getting a sibling's consent upfront is, I think, best practice, even though it's not a legal requirement. Okay, I have come to the end of my slides, and I am going to stop sharing here so I can see you all again and have you ask me any questions.
Okay, so thank you, Anne. The way that we are going to facilitate questions is I need you to either physically raise your hand like this, or if you would like to use the hand raise button, if that's available on your Zoom, that is fine too. And I will call your name and make sure you are unmuted. Now, because there are so many participants, it looks like my internet is unstable. Okay, because there are so many participants, I have you spread across 2 screens. And so I may not see you right away. So please wait for your name to be called because I see your hand. Oh, all right, I see Gerald.
Hi. Yeah, I wanted to, you talked a lot about caregiver agreement. Is there anything wrong with a family just agreeing that caregivers will be gifted and the gifting falls under the $15,000 amount? Is there any problem just doing it that way as opposed to doing a caregiver agreement?
Yeah, that's a really good question. So the IRS gifting rules are far more generous than the Medicaid gifting rules. So unless you have so many resources that you can absolutely guarantee that there will never be a need for a medical assistance application to be submitted, you know, even if you need nursing care of costing $15,000 a month for several years, you would at least want to be aware of the Medicaid rules and how they line up side by side with the IRS gift rules. So you're right, the $15,000 per year, perfectly fine. Never need to file a federal gift tax return. Medicaid would see those 15 years and say, whoa, whoa, no, you know, there's a problem here from a transfer for less than fair value perspective. But, oh, we see now we have a written caregiver agreement, no problem. Yeah. So, yeah, and you, even if you have a written caregiver agreement, you could still additionally, the de minimis gifting that Medicaid does permit. It's just a far less generous gift regimen than the IRS. Yeah.
Okay.
It's a $500 a month total gift limit for the 5-year look back period.
Okay. Thank you.
Per individual.
I see Faith Drummond next.
Bob, go ahead. Can you unmute?
Yes.
Oh, okay.
All I can say is wow. First of all, Anne, is there any way, is this going to be on a webinar or something that we can access? But secondly, I didn't get that date that you said the expressly granted powers. What's that date, and where can I find her about this?
Yeah. January 2015 was when financial powers of attorneys signed after that date were supposed to reflect the change in the law to include expressly granted power. In reality, we're discovering is that financial institutions are judging all powers of attorney presented to them by post-January 2015 changes. Isn't fair. And we've certainly pushed back and say, you know, goodness, people weren't all required to run out and do new powers of attorney as of January 1, 2015. You should be judging those older documents by the law as it existed then. And there was no expressly granted powers section, but that's not happening. I think it's just simpler to assess all documents by the same metric. As to whether, I think, yeah, Rod, there will be a recording of this available, right?
Right, and we'll get the word out of how people can access that.
Yeah, and
Well,
I could send a link to the Act, the Pennsylvania Act.
Thank you. Yeah.
And that's Faith. Okay.
Okay, I see Mary Kay.
I just have a quick question about the caregiver agreement.
Mm-hmm.
So the before and after part of it, let me see if I can put my question in clear terms. You could be in a situation where you have been giving care to a parent, but not getting paid for it. And then it goes on and you decide, maybe I better do that. And then you can continue that same level of care, but now you have an agreement, but you don't get paid until after the agreement goes into effect. Is that still legitimate? Or is it like, too bad, you were giving that care for nothing, you have to keep giving it for nothing?
Yeah, no, it's not like that. You could start receiving payment as long as there's an agreement. So often it will happen like that. I'll be told that a son or daughter-in-law has been giving care for 2 years already with no payment, and I'll recite that in the document to say, you know, it's almost just another measure of the integrity of this contract, that there's been this history of care, there was no payment, now starting this month and this month forward, this is the agreement, the care to be given. Not out of love in the past, not accepting payment.
And that can come, does not have to come from Medicaid.
It's not from Medicaid. This is a private, this is a private.
It's a private agreement, but it just doesn't turn into a disqualifier for future Medicaid.
Exactly.
Got it.
Yep.
Okay.
And yeah, we're sort of doing the written caregiver agreement because we think Medicaid might be looking over the shoulder of this elder person down in years to come. And we can help the caregiver determine what a reasonable payment is. Some caregivers have special experience and expertise. I've had caregivers who are registered nurses, or dietitians, or some other really relevant skill set that we can sort of justify a higher rate. And as long as everyone's in agreement, and the best of all is, of course, if the parent, him or herself, understands and can agree and acknowledge, and we don't have to go to the agent child signing this document. Yeah.
Okay, I see Janice and then Ken.
My question is, if you have a caregiver for a year and then you sign an agreement, can the agreement be retroactive? So you can pay them for that past year? that they didn't receive payment?
You said that one more, Janice. Did you say retroactively for the past year?
Yes.
You-
Yes.
I think it would be treated by, again, if Medicaid's never involved, no one really cares. But if it is involved on the road within 5 years of that, they're going to why that payment was made, because there was no agreement in effect to cover that period of time. It really should be a forward-looking document. Yeah.
Thank you.
If you make that payment and then you don't need Medicaid ever, or only need it in 6 years or 7 years, it again does not matter. The 5 years is a discrete 5-year period that once it has run, Medicaid has no interest in the history of transfers that occurred outside of that 5-year period. But they have intense interest in scrutinizing bank statements and checks written within that 5-year period. Yeah.
Thank you.
My question to you, Ann, thanks for this. I don't have our financial power of attorneys in front of us, the ones which you wrote for us in 2013.
Yeah,
I don't know whether the expressly granted powers, were you putting language into those even before it became law?
Yeah,
and if
we did
not,
add a whole, we did add a whole new section in 2015. Some of the expressly granted powers we were already including. We didn't call them expressly granted powers because they didn't exist. So I don't want to tell people they should all rush out and do, redo their powers of attorney. But if there's a reason why you're doing other things, then go ahead and update your documents, because it's just going to save grief and aggravation, for an agent. Especially if I have clients where I can see one of them is heading to, a nursing facility or a waiver application or a caregiver agreement kind of scenario, then we're going to want to beef up those powers of attorney and make sure that the agents are just not going to get hassled by any bank or any financial institution, and that they're going to have all the powers they need to do anything. Yeah.
I guess my further question to that was, if there's can you just add a supplement? Is there language that you would provide just to add a supplement to a current will that if signed would then add that into the agreement that's already, without having to sort of redo the whole thing?
Yeah. So this really doesn't impact the will at all. And for wills, we do have codicils, but we're talking here about the lifetime powers of attorney. We don't do amendments to powers of attorney, but they're not expensive. Like, we have templates for them, so they're not costly. But a will, you can make changes to, but this just isn't relevant to the will because that's after death. So this is a lifetime power of attorney change. Yeah.
Okay. Elizabeth?
When you're talking about assessing a person's assets or income, if a couple has joint accounts, how is that done? Yeah.
So the broad categories of resources. So I talked about distinguishing between income and resources. Resources further have their own 2-category distinction. There's countable resources and there's non-countable. Non-countable resources, that would include things like, well, let's just say, that was Elizabeth asking that question.
Right.
Let's say it's Ken that needs the Medicaid application. In the non-countable column for the 2 of you is going to be all of your qualified retirement accounts. The non-countable category is a golden 2 thumbs up category, because what it means is it's fully off the table and protected. So if Ken is the spouse for whom we're seeking financial eligibility, we know about and we disclose your qualified retirement accounts, but they don't enter into our calculation. Likewise, your home, your primary residence, even if you and Ken own it jointly, we know about it, but it's a non-countable resource. What's countable, on the other hand, is all of those joint non-retirement investment accounts that you and Ken have, all those joint bank accounts, Ken's own qualified retirement accounts. What else? That second car that you have, those we put in the column called countable, and we add it up, and then we do a calculation that you probably did February a year ago in that seminar. It's a rather complex calculation, but the whole point of that is to determine, besides all the non-countable that Elizabeth can keep, there's also a number for countable resources Elizabeth can protect as the spouse of someone whom is seeking Medicaid eligibility. And anything that's left over after that we call excess, and that's where we have to do some kind of spend down process. So yeah.
And who helps?
Who
Do
helps
you help?
do that?
Does the attorney help? Oh, I'm sorry.
Helps. Yeah, we do that a lot, especially because the married couple scenario is more complicated. It's not just a matter of how much money we have. It's a matter of characterizing each asset as countable or non-countable, then doing the calculation. And yeah. So, and I always want to stress to people, medical assistance is not, it's not for, you know, just extremely impoverished. It is for extremely impoverished people, but it's not only, because as I said, the law has anti-impoverishment provisions built into it. The law is aware that it does not want a couple, you know, to be completely impoverished by the cost of care. And so there are protective rules if you're aware that they exist, you know, yeah.
Janet?
Yes. So, Anne, when you were talking about the long-term care insurance, you mentioned several times Pennsylvania long-term care insurance. So is it something that should be a Pennsylvania company or what?
So yeah, there are some policies that are like, I've had clients who've had a policy through another state. So if it's just a commercial carrier, it's probably going to be, you know, acceptable anywhere. But the Pennsylvania Department of Insurance has, you know, some rules about long-term care insurance, that policies that are approved to be sold to Pennsylvania residents. So they would have extra protections in place for those. So yeah, I mean, you could actually look probably on the Department of Insurance website if you're not sure whether those protections would apply to a policy you have. You could look on their website. I think they have, under their long-term care insurance prong, they have a list of companies that they have, you know, agreements with or with. But yeah, if it's a policy that was approved and is, you know, it's one that was sold to Pennsylvania residents and approved for sale to Pennsylvania residents, it should be subject to those protective kinds of characteristics, that it has to have home health coverage. Yeah, the Department of Insurance for Pennsylvania also has something called a partnership policy, which is a special long-term care insurance that allows you to protect more assets because you put your skin in the game and bought this long-term care insurance, but that's a different matter.
Okay, thank you.
But if you have a partnership policy, that's a really valuable additional perk of long-term care insurance. Yeah.
Thank you.
I see Faith.
Yes, just real quick here, my battery's getting low. I was told by a doctor, I told him I have a living will and medical power of attorney, and I can't recall why he said it wasn't worth that much. What you really need is a post.
Mm-hmm.
And could you, I don't know if that's within your realm, but could you clarify that a little bit? And now in this area of COVID, if you get on a ventilator, how does that work?
Yeah. So a POLST is a really good document. It's a Pennsylvania order for life-sustaining treatment. It's probably not appropriate for someone who is not in a kind of a terminal condition, or it's not, you know, I don't tell all my clients to make sure they have a POLST unless, you know, they're in maybe a nursing facility that requires all its residents to have them, or unless they together with their doctor have conferred and it's agreed that they may be within their last, you know, 12 months of life. The POLST is a really good document. I agree with your doctor. It's got more teeth because it's a doctor's order. It's a medical order. So the O stands for order, you know, so it's a doctor saying, I've had a conversation with my patient Faith, and we've agreed that these are the interventions, you know, that she is or is not going to have if she's in a, you know, a cardio kind of event or a respiratory event. And it's a doctor's order. My document that I do as an attorney is a legal document, but I think the POLST has more teeth. And if I were in kind of an end of life, if I had a diagnosis where I was in an end of life scenario, I would want to talk to my doctor and have a POLST in place. In addition, I would have one in addition to a living will, healthcare power of attorney, but I like the POLST quite a bit too. And an agent, a healthcare agent, can sign a POLST if the principal no longer has that capacity. The doctor could have a conversation with your agent, and your agent could sign that POLST together with the doctor's, you know, with the doctor's input and all of that.
Make sure you're unmuted.
COVID. So some of my clients have said that before they would have said in their living will, I decline all mechanical respiration. And now they're seeing that, you know, a percentage of people can be on a respirator and come off just fine and have a good quality of life. And so they're kind of nuancing their living will to say to their agent, please have a conversation with my primary care doctor. And if you feel that there is a reasonable hope that I can spend a period of time on a respirator and then come off, and you know, I'm going to leave it in your hands. I'm not saying carte blanche, never any respirator, because they're, you know, they're seeing a scenario where that might be appropriate.
I see Mary Kay.
I would just wanted to add something to the POLST conversation. My mother broke her leg last Thanksgiving, and while she was in rehab for that, so she wasn't, nothing to do with end of life, but just in the rehab facility, the doctor came in and had her fill out a POLST and sign it.
Okay.
I'm wondering if, pardon?
Yeah. How old was she at that time?
93. Well, she was 92 then. She's now 93.
Yeah.
I'm curious about that particular document. That doctor obviously is not her primary doctor. He was the doctor at the rehab facility where she was. But is that still a legitimate, like, we've been holding on to that. She's been in the hospital for a couple of different things, and we of course we never remember to bring it, but we haven't needed it either. But we've been holding on to that as if it's the other thing that we might need if something happens. Does that need to be redone by her own doctor at a later stage, or is it good to go?
I think it's enforceable. I would make her doctor aware of it if she or he isn't already aware of it, just to make sure that the doctor who knows her best feels it's appropriate.
Thank you.
Yeah, but I think it's enforceable. It's still legitimate, even though not done by her primary care doctor, is what I would say.
Okay. Any final questions? All right. Seeing none, One more. Last question from Faith. Oh, you're still muted, Faith. There we go.
It seems like with single people, things are much more complicated with look backs and caregiver agreements. It sounds to me that, and I'm not the attorney, but the best advice would be to consult an attorney if that's the case. And I thank you and the attorney for providing this really interesting seminar for us.
Well, thanks. I think it's actually simpler for single people, but that's because they can't take advantage of some of the more complex spousal anti-impoverishment rules that make the calculation of protecting resources more complex for a married couple. So sometimes, you know, a caregiver agreement or a Medicaid application for a single person can be much simpler because we simply don't have some of the same options for protection of resources. But yeah, of course, I'm all for consulting an attorney just because we end up with the things that go wrong. So, you know, where people had absolutely the best of intentions, but just didn't know how what they were doing would be viewed by certain financial institutions or a government agency. So yeah, we think we get to spot those issues in a way that maybe the lesser trained eye might not spot those. But yeah.
Okay, thank you very much, Anne. Thank you. I know we'll give a muted round of applause.
Okay, great.
Thank you.
All right. Good.
And this was recorded, so we will send out the link if there's a part you want to go back to, or if there's a downtowner you know who wish they could have been here today, but it didn't fit their schedule. And that's all for today. Hope everybody has a good evening. And we'll see you next time.
Yeah. Have a good evening, all. We'll see ya.